Welcome to Employers Assistance pre-recorded webinar series. My name is Kent Duffy, lead solicitor and employment lawyer here at Employers Assistance. Today we'll be talking about 90-day trial periods and probationary periods and a summary of the key considerations and or important information that you need to be aware of as an employer when navigating this particular area of employment relations. In terms of an agenda for informing this presentation, we'll be looking principally at 90-day trial periods, but also probationary periods in terms of understanding the distinction or difference between these two contractual mechanisms. Then on to some dialogue regarding the compliance requirements and key information and top tips when utilizing 90-day trial periods and why these considerations are so important for employers to get right within this context. Then on to some common issues and pitfalls regarding 90-day trial periods and the sort of common scenarios that we see where these things can invalidate 90-day trial periods, and unfortunately for employers, consequently, they lose the protection that the 90-day trial period affords, which is to protect it from a claim relating to unjustified dismissal. Then finally, just some general comments towards the back end around employers' assistance's tools and resources that we have available for our members in this particular area of employment relations or employment law. Now, 90-day trial periods and probationary periods are very distinct, and it's imperative that employers understand what the distinction means when using either of these clauses. Both of them are about testing a new employee's suitability for employment. However, a 90-day trial period is much stronger. Essentially, it is tantamount to an employer's silver bullet, for want of a better terminology. The key or most important thing to understand here is that if an employee is dismissed under a valid, and I use that word valid, 90-day trial period, and I'll come back to that, then they cannot raise a personal grievance in respect of their dismissal. An employer is not obligated to implement a fair process when terminating an employee under a valid 90-day trial period clause. So effectively, it acts as a sealed door, or the trial period acts as a sealed door on the ability of an employee or ex-employee claimant to be able to successfully raise one of the most common claims, which is for unjustified dismissal. The key distinction in terms of coming back to the difference between a 90-day trial period and a probationary period here is that an employee can raise a successful personal grievance claim in respect of a dismissal under a probationary period, whereas they can't do that under a 90-day or a valid 90-day trial period. So the short point here is an employer's termination process, or the procedure that needs to be implemented or followed, the paper trail, if you will, under a probationary period must be fair and procedurally sound, namely a truncated performance management process or a formal performance management process, a PIP, if you will, and the employee is free to challenge that decision to dismiss them in the context of the probationary period. Whereas that's a lot harder or near impossible for an employee to do so if they're dismissed under a valid 90-day trial period. 90-day trial period and key compliance requirements. So all of these points or features that you see on the slide need to be met and complied with when using a 90-day trial period if the employer wishes to ensure that that trial period remains valid and has the protection to effectively extinguish any subsequent legal claim for unjustified dismissal. So running through them quickly, they can only be used for new employees. So that means you cannot use a 90-day trial period for any previous person that the business or the employer has previously employed, no matter the capacity. So for example, if you as the employer had employed, say, a fixed term employee for a few months over a Christmas period or peak season perhaps 10 years ago, you would not be able to use that 90-day trial period if you're subsequently looking to re-employ that person under a permanent employment agreement, say. They can only be used for new employees. So, effectively people who have never worked in the employer's business in the capacity of an employee. You must have a compliant 90-day trial period clause. This is very important. So this pertains to the particular wording or specific wording that needs to be in that clause. Reference to the fact that if the employee is terminated under the trial period, they are precluded or cannot challenge the dismissal due to the 90-day trial period or the effect of that clause. We have compliant wording embedded into our employment agreement builder on point there that you can have a look at. You must provide a reasonable opportunity to seek independent advice on the offer of employment prior to that individual person starting work. So the suggestion there is at least 3 to 5 working days between when you make the offer and the employee subsequently commencing work. The more time the better there, so personally I would advocate for at least a week, but nothing is written in stone there. They must have enough time to basically go and seek some independent advice, so see a lawyer, say, and arrange an appointment for that purpose as an example. Now, the other really important consideration here, and this is one that often employers trip themselves up on, is that the employment agreement with that 90-day trial period clause in it must be signed and returned prior or before them starting work. So don't let the employee come to work on their first day of employment and sign that contract 10 or minutes or half an hour after their start date. If that occurs, you've lost the protection. The trial period's gone because they are not considered a new employee at the time they sign the contract. So always ensure you get that contract signed and returned well in advance of their start date. So ideally a day or 2 or 3 if you can manage that before their first day of work effectively. A 90-day trial period cannot be extended beyond 90 days, and it's 90 calendar days. That's the maximum that you can use these particular clauses for. So again, not working days is the point to note on the slide there. And notice of termination, if the employer has made the decision to terminate under the 90-day trial period, must be given before the end of that 90-day period. And you must give notice correctly. So you need to consider the wording of the clause and the employment agreement in terms of how you give notice there. And what I'm alluding to is, do you have the option to put the person on garden leave, or potentially maybe pay them in lieu of notice, or are you going to require them to work out a reduced notice period, say? You may have a standard notice period for termination or resignations of 4 weeks. That's fairly common, but under a 90-day trial period termination scenario, you may reduce that to only 1 week. So again, notice needs to be carefully checked and what the specific obligations are around that. Employers under an accredited employer work visa or AEWV cannot use 90-day trial periods for migrant workers anymore. Common issues and pitfalls in the context of 90-day trial periods. So just quickly, not having a compliant 90-day trial period clause in the employment agreement is one that we sometimes see. And that scenario typically is either not having a 90-day trial period clause at all and just assuming that it's a given that, without that clause we can still terminate an employee under a trial period scenario, even in absence of a clause on point. That's not correct. It's again really important that the wording of the 90-day trial period clause is in the employment agreement in order for it to be valid. Some of the other common pitfalls there is not giving enough time for a new employee to obtain independent advice. So again, that's the time period between making the offer and them starting work. So the example, or one that I sometimes see that can be quite common, is the offer's made on the Thursday or the Friday, quite late in the afternoon, with start date the following Monday. So if you extrapolate the requirement in law to give somebody a reasonable opportunity to get independent legal advice or independent advice, that cannot be met in those sorts of circumstances. Why? Because generally professional service firms like lawyers or consultants are closed over the weekend. So just reiterate, like that's a important consideration to make sure that you have enough time between making the offer and the start date for somebody to go and get that advice. The next one there is failing to ensure the employment agreement is signed and returned prior to starting. And a common scenario or situation there is the employee shows up on the Monday for their first day of work and has some sort of reason or excuse as to why they were unable to sign the contract, and maybe they didn't have a printer or a scanner, this sort of thing, and they subsequently sign it later in the morning. And in that scenario, any lawyer or advocate knows that immediately that would have invalidated the trial period, because the law or the Employment Relations Authority, as an example, generally would consider that sort of situation non-compliant in terms of the requirement for the person to be a new employee. Namely, they were already an employee at 8 o'clock when they arrived to work, and they didn't sign the contract till, say, 10 o'clock later in the morning. It's that sort of thing. So really important you get it signed and returned prior to their first day of work is the short point there. Failing to give notice of termination before the end of the 90-day period. So, the 90-day period, calendar days lapsing, and the employer wanting to terminate on day 83 or 93 or 95 as an example. Well, once that 90-day and calendar days again is expired, or rolls over, that the trial period is extinguished. Effectively, it's gone. So these are just things to keep a very close eye on in terms of not falling into the trap or the pitfalls associated with these features. Key information and top tips. Larger employers can again use 90-day trial periods. Previously, this was limited to small employers. So from memory, it was employers who employed 19 or less employees. That particular requirement has been removed or appealed via, I think, National Act, New Zealand First Coalition Government in December 2023 from memory. So again, large employers can use these 90-day trial period clauses now. Employees can still raise other legal claims for other problems outside of the dismissal. So for example, unlawful discrimination if they're unlawfully discriminated against, and or sexual harassment if they were subject to those sorts of situations. So if it's for a matter or a claim that is unrelated to the dismissal and the 90-day trial period, then there is always risk inherent with other sort of claims proceeding. For example, an unjustified disadvantage grievance, which is unrelated to the dismissal, or a sexual harassment claim entirely based on some sort of abhorrent conduct towards an individual or worker in the workplace context. It's always important to ensure as the employer that 90-day trial periods are set up and implemented correctly. So you have a compliant clause, and again, that comes back to the wording that I alluded to before, that a sufficient time is given to the candidate or new employee to seek independent advice, and that they sign and return the employment agreement in advance of their start date, etc. The courts do not like 90-day trial periods, and this is due to the severe consequences that they have for employee rights. Effectively, they obliterate an employee's ability to raise, like I say, one of the most common claims, and that's for unjustified dismissal. So it's important to understand that the Employment Court and the Employment Relations Authority take a very strict approach to interpreting the compliance requirements related to 90-day trial periods issues. So the key here is that compliance is paramount. It's important that you understand and you take the time to understand their basic legal requirements and that you implement them correctly. They are pretty straightforward, but it's very easy to miss some of the compliance requirements, and where that occurs, the trial period protection is lost, like I mentioned before. Consider having a reduced notice period under the 90-day trial period, and I mentioned this before. So rather than your 4 weeks general notice period of termination or 2 weeks, perhaps only have 1 week is the key sort of message there. Other key information and top tips regarding 90-day trial periods. This is quite an important one, this first point here, and that's staying away from paid or unpaid work trials when using a 90-day trial period. These sort of situations where an individual or a worker engages in a paid or unpaid work trial prior to them starting employment has the absolute risk of the trial period being later declared invalid on the grounds that the initial work trial was employment and therefore the employee was not a new employee for the purposes of the 90-day trial period. So this is really important. There's been a plethora of cases regarding this sort of issue. I recall there's a number of cases involving sort of coffee houses or cafes where the cafe owner will get the person in to make some coffees for a couple of days, either as a paid or unpaid work trial or premised on that, and then later offer a job subject to a 90-day trial period and move to terminate on that basis later on if things aren't working out. And then in a litigation context, the trial period being invalidated because the ERA, for example, takes the view, well, no, that person was already employed at the time that they were making those initial coffees in the context of the initial work trial prior to them actually being offered the employment agreement and formally starting work as an employee. So it's just really important to be aware of these things when you're using these clauses, because if you get it wrong, you lose the protection that the 90-day trial period affords. And again, it's a very powerful or strong protection. It's effectively an insurance policy, for want of a better word, when you're hiring new staff. Ensure any offer of employment letter references the 90-day trial period as good practice. So rather than it just being buried away at, clause 25.6 or whatever it is deep in the employment agreement, that it's up front and it's signaled, flagged in the job offer itself. And, the candidate's on notice that during the first 90-day trial period, first 90-day days of their employment, that they're subject to that trial period of the same duration. And any verbal dialogue around the offer of employment, it's a good idea to mention that so everybody's on the same page, that effectively the candidate is on notice that their suitability is being carefully monitored during their initial work period. And again, always ensure that the new employee signs and returns the employment agreement with that 90-day trial period well in advance of starting work. I can't reiterate that one enough. It's a very common issue in terms of matters that I'm involved in where the trial period and the protection is being lost simply because the employer's failed to meet that very basic compliance requirement and they've left it too late or have not got the agreement signed at all. It's an unsigned contract prior to the person starting work. So really important again. Now, just finally on some general tools and resources that Employers Assistance has available for our members that you can access regarding this particular area of employment law. So we have the 90-day trial period exclusive section on the toolbox, which is our website where you can find basically all the key information that I'm talking about in this presentation in one succinct area. So we have a more detailed ebook on 90-day trial periods and probationary periods that can also be accessed there or in our ebook section or library of the website. We have the 90-day trial period calendar calculator where basically you can check the dates or double check, triple check the dates just to make sure that you are still inside the 90-day or 90-day calendar time frame before you get to a point where you're terminating. And we have the trial period wizard checklist. So this basically is a question and answer feature of our website where it will ask you a series of questions along with all the important stuff that I've talked about today to ensure that your trial period is compliant before you hit the green light on a termination letter, which brings me to the last point, that there is a sample letter template for giving notice of termination under a 90-day trial period clause. So that concludes today's discussions in terms of this presentation. If you need any support, then feel free to call us on our 800 number, and that's 800 15 8000, 0800 15 8000, or visit our website for more information. Thanks very much for your time today, and I hope you've got some meaningful information out of this presentation. Thank you very much. Bye-bye.